prosecutor can pursue an unconstitutional prosecution without hesitation or reservation. They have nothing to fear. They are immune from lawsuits. They know they're not going to be penalized or punished by a state bar, by a disciplinary committee, et cetera, et cetera. They have nothing to fear. In 1940, then U.S. Attorney General Robert Jackson, who later became a Supreme Court justice, warned that, quote, the prosecutor has more control over life, liberty, and reputation than any other person in America. He warned that prosecutors could easily fall prey to the temptation of, quote, picking the man and then searching the law books to pin some offense on him. Prophetic words indeed. Because in a society where racking up convictions tends to win prosecutors promotions. It enables them to pursue a higher office, like, say, district attorney. And of course, it can be one route to high-paying jobs at major law firms, say, for example, here in Center City. In a society where racking up convictions can be beneficial to the individual prosecutor, the temptation to search the law books, to pin some offense on a vulnerable party, say a destitute, indigent minority who nobody cares about and can't afford an adequate legal defense, the temptation is overwhelming. It is often too great for a prosecutor to resist. I'll be blunt here. In our society today, too many prosecutors are getting ahead in their careers on the backs of vulnerable, powerless, poverty-stricken racial minorities in the United States. That is the reality that we face in the American criminal justice system today. So you ask me, what is the answer? Well, in my Capstone project, I put forward a number of suggestions and proposals to reform the American criminal justice system. What were some of those suggestions that I touched on? Well, first and foremost, the absolute immunity enjoyed by prosecutors in the United States must end. All of you are aware of the fact that, say, a physician or a doctor can be sued if he or she engages in malpractice. Virtually every profession in the country has some kind of malpractice insurance to protect them in the event that a mistake or blunder or error is made and they are held accountable. Why should prosecutors be any different? Why are prosecutors the only human beings in our present-day society who cannot be sued if they make a grave error in judgment? This reform, from my standpoint, is urgent and has to be adopted immediately. A criminal defendant is held accountable when he or she commits a crime or makes an error in judgment. Why should a prosecutor not be held accountable if he or she makes an error in judgment or, heaven forbid, commits a crime? Another proposal I put forward in my Capstone project is the adoption of a loser pays rule. A loser pays rule should be adopted for criminal defense costs, wherein the prosecution pays a criminal defendant's legal fees if the defendant is acquitted, or if the charges against the defendant are dropped at a later date. This would give prosecutors in the United States pause. It would cause them to be far more reluctant to pursue cases that are questionable or are specious in some way, shape, or form. No question about it. Again, why should prosecutors not be held accountable by society if they make errors in judgment? Another proposal I put forward in my project, plea bargains must be done away with altogether. Plea bargains have been abused by American prosecutors, and racial minorities and poor people have been victimized as a result, time and again. The incentive to overcharge a criminal defendant would be eliminated if plea bargains were done away with altogether. These are but a handful of possible reforms of the criminal justice system, possible reforms that would lead to genuine change for the better if they were adopted and they would reduce the racial disparities that plague the criminal justice system if they were adopted. The burning question, of course, is why have such reforms not been adopted? Amidst all the discussion of criminal justice reform, the issue of America's prosecutors and their conduct is seldom, if ever, touched upon, even among the most outspoken activists. And reforms of prosecutorial behavior and misconduct are seldom, if ever, touched upon. Why has there been no real reform? Why all talk and no actual, genuine reform of the criminal justice system? In my Capstone project, I put forward an answer, and it's a very unsettling one. The grim reality. I'll quote from my Capstone project. Mass imprisonment in America has become a mechanism for the subjugation and subordination of marginalized populations, specifically persons of color. Indeed, the criminal justice system as a whole has become a vehicle for the control and subjugation of colored persons. America's prosecutors are the principal players in the criminal justice apparatus, and they have established a conviction culture that is stubbornly resistant to change. These, I stress in my Capstone project, are the underlying reasons for the U.S.'s continued non-adherence to the convention and to why America remains a voluntary outcast. Very blunt, very unsettling, very distressing. Oh, this is hyperbolic, Mr. Clyburn. This is an exaggeration. This can't be. Again, our country is a beacon of light, a democracy. What you're suggesting here is absurd, preposterous. Is it really? We are currently at the apex of the era of neoliberalism, an era where government assistance to the needy, to the poor, to the elderly has repeatedly been curbed, when poor people have suffered, when the wealthy have amassed tremendous amounts of wealth and power at the expense of the common man. Given that we are in such an era, is my hypothesis really still preposterous and unsound? And I ask you, if my thesis is unfounded, then why hasn't criminal justice reform become an empirical reality? Examine the empirical facts for yourself. Has mass incarceration resulted in a dramatic reduction in crime? The reality is the United States still has the highest crime rates of any country in the world. That's right, any country in the world. Mass incarceration doesn't appear to be working. So why does it persist? If the aim is to diminish and reduce crime, well, it's not working. We still have the highest crime rates, not only of any industrialized country, but of any country in the international system. So if the aim isn't to curb crime, then what is the actual aim? What is the actual objective? Something to ponder. I ask you to ponder my thesis, as unsettling and distressing and disturbing as it is. And to bear in mind again that if we are to be a champion of human rights, if we are to be a dominant actor in international affairs, we must not only fulfill the obligations that we have made in terms of treaties and accords, we must serve as an example to other free and democratic societies. Thank you all for your time.